All right, good day, good day, good day, and good day, and more good days. Welcome to another episode of Sensible Reactions. All right, so listen, this one is a little lengthy, okay, and I'm glad this was my last one because, girl, this one is about 7 disadvantages of putting your home into a living trust. So I'm going to say this disclaimer. This time I'm going to move along this way. Please do your own research, okay? Please do your own research. All right, now we are going to be reacting to this video, of course, but there are 3 videos before this video. Here they go. Okay, there they go. I need you to go back. This is episode 14. I need you to start at episode 10. Unless you already know all of the things in the previous episodes, then you need to go back. Then, if you don't, if you don't know, you need to go back. If you do, stay here, stay with me. We good. Let's keep it moving. So, I really want us to. I don't own a home at this time, right? But as young entrepreneurs and as a really a person of any age who has their own things, you need to kind of start to get their mind right, handle your business, because we lose out a lot even after we gone. But it's a lot of benefits to having these things while we are here. So I also want that to be something you keep in mind as well. But with all good things, sometimes comes the poo-poo things, right? That we gotta deal with, and it just is what it is. So I'm interested in seeing what are the negatives, because I've heard a lot of positives, some negatives, depending on the situation. Like when it comes to having a will only and no living trust, going through probate, all of that stuff. So let's get into this. Like I said, it's quite lengthy, so I want to kind of like hurry up because this is like 20 plus minutes. So yeah, let's go ahead and get into this.
Hey guys, Shelby Mathis here, and today we're going to go over 7 disadvantages of...
Oh yeah, really fast. I'm speeding this up just because it is a little lengthy. If you need to slow this down, there is a screw. Okay, at the bottom, let me show you. Matter of fact, let me just show you. See this button right here? Okay, you go to playback. You can customize this however you want to. Okay, right now I have it on 1.5. Okay, you can put it on normal if you want to. Okay, now it might change up when I come back in and talk, but I'm pretty sure you can deal with that. I ain't talking for too long, so cool.
Of putting your home into a living trust. Now, you guys have been listening to me for quite some time. You know that I really like living trusts, and I say that everybody really should have them because there's so many aspects of a living trust that are absolutely critical, like the power of attorneys for healthcare, for financial, HIPAA releases, and then making sure that you skip probate. But let's talk about some of the disadvantages that come along too. And I want to be really fair, so I'm going to do some pros and cons, but let's start with the cons. Number 1, and this is an obvious one for anybody who sets these things up. We're just going to go over here and do cons. Make a little line here. The first one is the cost of setting it up. So living trusts aren't free. There is time and paperwork, so there's expense.
That answers my question that I had in a previous video. So now you have the answer if you've been following along, class.
And paperwork. Not super simple just to go ahead and clap your finger and it's done, but there's costs involved in actually setting up a trust, and then you actually have to transfer the actual home into that. So there's expense and some paperwork when you start. Now, if your house is actually a living trust, then you might have some issues when you refinance. So whenever you're doing refinancing, you probably should take the property out of the trust first. Like there are banks that'll refinance inside of a trust, but you're going to add a little bit of complexity that you might want to just ignore by just take the property back out of the trust, refi it, put it back in. They'll oftentimes do that at the closing table for you, by the way, when you're doing when you're actually sitting with the title company. So there is a little more paperwork when you're using a living trust, just to be straight up. But at the end of the day, if you don't, it goes with you, which means it's probated. And if you have multiple properties all over the place, then you can be probating in multiple states. Number 3, and this is one, just to be clear, there's no asset protection. Not while you're alive. So living trusts are a grantor trust. They're revocable, and they provide no real asset protection benefit while you're living. When you're passed away, then there's credit shelter provisions that can be very strong. But while you're alive, not so much. So it's not something that you're putting in place by itself. Hey, I put it in a living trust, therefore my creditors can't get it. No, it's the same as it being in your name when you put it in that living trust. There are things you could do with your home.
Because, see, people make it seem as if that's the case. Do your research, though.
To protect it, but this is not one of them. All right. Number 4. And this is a sometimes deal. You're going to have a little bit of hassle with your property taxes.
You guys, funerals cost at least 15 grand. I mean, do your loved ones have 15 grand to spare? Because I know mine don't. So for less than 20 bucks a month, I got my plan from lifecompared.com.
If the county knows it's a living trust, you shouldn't have any issue. There's no place that we deal with where there's reassessments anymore. But you're going to have to provide them with a certificate of trust, or they're going to have to understand that it's a living trust when you do it. You may get some pushback. So I just want to be clear with you. There's a value in doing this. Every now and again, somebody doesn't know what it is, and when they don't know, then sometimes they act negatively, and they go, oh, you're transferring it into something or transferring it to somebody else. If they know it's just a living trust, they're very common now. When I first started doing this 27 years ago, not everybody knew what living trusts were, and it was much more difficult. Now, pretty much everybody knows what a living trust is, and they go, okay, yeah, there's no reassessment on property taxes. Here's another one, and this is just to make sure that we're clear. No estate tax benefit. I don't want to mislead you guys. There's no estate tax benefit when you're using a living trust. Now, sometimes it comes in when there's no portability in the code, which there is right now, where then the trust, yes, it could have an estate tax benefit, but as we are standing here right now, there's no real estate tax benefit that comes along. It does not avoid anything that has to do with estate taxes. So I don't want you to think that, hey, I did a living trust, and therefore, if your estate is large, you got a $20 million estate, which isn't going to be a big issue if you passed away now, might be if the Tax Cut and Jobs Act expires and they allow those provisions to sunset and the estate tax reverts in a couple of years to, $7 million, all of a sudden you may have a tax issue. I don't want you to mislead you. Living trust is not what the planning, that's not the planning that's going to help you there. You got to do another level. Number 6, as far as a disadvantage or a con, would be the potential loss of a homestead. Now I'm just going to write down homestead, because nowadays, never an issue. But if you transfer it into trust, if it's obviously your living trust, nobody's going to have an issue. It doesn't do anything with your homestead exclusion. If you're transferring it into a trust and you change the name or something, you may have somebody push back a little bit. Generally speaking, as of this point, nowhere am I aware of where it's going to hurt your homestead. But it's something you want to be aware of, that pops up from time to time, and states can do what they want sometimes. Now, there's no reason why it doesn't give you asset protection. There's no reason.
Honey, you said that for sure. They try to do whatever they please. That's my only problem with buying land in the United States, is because these states decide to do whatever they want to do, and it's almost like erasing you as an owner. Well, what did I pay?
Reason why it should cost you your homestead. But in the abundance of caution, I'm just going to raise it as an issue so that you're not surprised if a county says, oh, what about you transferred it, you lost your homestead, and it's like, no, you didn't lose your homestead. They don't understand that it's a living trust. Sometimes they think, oh, you transferred it to somebody else. Not the same thing. All right, and 7, the last disadvantage of transferring your house into a living trust is living trust. Sometimes there's complexity and amendment. So if you're going to change things, I'm just going to put amendments. They have to be in writing. For example, there's always going to be an element of a formality if you're going to change the trust. If you're going to make changes or restatement, you can do it at will. Because a living trust is a grantor trust, it's fully revocable. You can change it whenever you want, but you want to make sure that you're documenting those changes. And so just, again, exercise of abundance of caution. I'm just trying to give you every disadvantage I can think of. It's slight, and it's way easier, by the way, than if you did a codicil on a will, but I don't want to mislead you. It's still an amendment. You got to make sure you sign it. And it's way easier, by the way. Exercise of abundance of caution. I'm just trying to give you every disadvantage I can think of. It's slight, and it's way easier, by the way, than if you did a codicil on a will, but I don't want to mislead you. It's still an amendment. You got to make sure you sign it. You have somebody else, possibly, depending on your state, you might have to have it witnessed. Sometimes it makes sense to have it notarized just to make sure that you never have an issue of it creeping up in the future and somebody saying, oh, they didn't do the amendment right. No, I want to make sure that you're dotting your I's and crossing your T's. Of course, if you're working with Anderson, it's easy. We take care of all that stuff for you. We have these never-ending, these, kind of our forever trusts. The unlimited living trust is what we call it, where we do amendments every year. It's all included in the initial price, so there's no cost to it. But some places, they may charge you on that amendment. All right, what are the advantages? So let's just say pros. Why are we using these living trusts? What are the big ones? And the biggest one, obviously, for most people, is you avoid probate. Many states have statutes that allow a certain amount of cost to be automatically given to lawyers and to personal representatives if you go through probate. So we don't want to go through probate if we can avoid it. We want to avoid probate. On average, the cost, depending on who you look at, some of the larger bar associations look at it being, on average 3 to 8%. When you talk to ARP, they did a mid-level, mid-sized estates, and they found it to be as high as 20%. Whatever that number is, it depends on your state and how complex probate is. You could avoid it with your living trust. That's why there's such a there's.
And probate, that percentage from what we learned in the last one, whoo.
So powerful, and it keeps you from having to go through a long process to distribute assets. For example, many states, they will not transfer real estate for a minimum of 6 months. They'll tie it up, so you can't do anything. You're going to be stuck, or you're going to end up having to petition the court to enter into transactions. And if you're in a market like we had in 2008, or if we're in a run-up market, or if there's something going on with that property, or if there's any sort of financial difficulties, that could prove like very, very disruptive to you. So what are the pros? The pros, it avoids probate, which means less expensive and faster distributions. Number 2, privacy. So a probate is a public record. So if you have a property that goes through probate, or an estate that goes through probate, you're disclosing everything about that estate. Anybody can go look it up. Anybody can go in and see. So when you use a living trust and it avoids probate, it's a private matter. You and your trustee are handling it. You're passed away, but your trustee and your beneficiaries are handling it. It's not a public record. Somebody cannot go up and say, oh, what do they have? And there are cases where we've had burglary rings targeting probates, where they would find out out-of-state beneficiaries, here's what's in the house. You're giving them a shopping list. Unfortunately, that's happened where people actually look at it. There's still groups also that target marketing by going out and getting probate records. If you've ever dealt with real estate investors, you know that sometimes they target the probates, especially if there's out-of-state kids and they're trying to get a good deal on the real estate by saying, hey, I'll buy it. Pennies on the dollar, so you don't have to deal with the whole probate and everything else. They're doing it. It's taking advantage of the situation. Some people might say, oh, they're doing a service. They just saved you having to go through all that pain. It's tough. But I like the privacy. Flexibility. Control during your lifetime.
Good one, my guy. Good one.
Easy to change, easy to alter, and then probably the most important factor. If something happens to you during your lifetime, your living trust actually kicks in. It's not effective when you die. Like a will, you probate it. Will doesn't do anything while you're alive. Living trust absolutely gives somebody the ability to step in and handle your estate, your trustee, your successor trustee. If you're
okay, hold on.
Incapacitated or otherwise unable to handle your estate, you could have somebody step in and.
Okay, so now that answers my question. See how you gonna get all the answers you need. Okay, so that answers my other question that I asked in another video. If you were to get sick, would someone be able to step in, manage your... Okay.
And still give you, and still make sure that your wishes are being maintained. And basically, I would term it this way. You basically have lifetime management. While you're able to, it's you.
I would think that you would be able to, but sometimes what you think is common ain't that common, so...
When you're not able to, you have somebody else. Then when you pass away, you could have that same person or perhaps somebody else come in and manage the estate after that point. So it has during your lifetime, you can have a successor trustee, maybe it's one of your kids or whatnot, and you could still say, hey, when I pass though, I want to make sure it's, a non-interested party, maybe it's a bank, maybe it's attorney, CPA, maybe it's your uncle, somebody who's not a beneficiary looking at it. And that, and that takes that's a huge advantage. And I'm going to put that up there as well, and that is during incapacitation.
This is pretty much giving me, if you watch Zach and Fatima, then you know when Zach's mom passed and, dang, what's her name? Homegirl, you know who I'm talking about if you watch it. Homegirl was over the money, her insurance policy, she was over everything and had to organize it to where them two crazy brothers can... So yeah, both of them been watching.
That there's ease of your estate during incapacitation. So we don't have to go through the state and start guardianship proceedings or a conservatorship. You have it already covered inside the documents. In fact, in our trust and almost all trusts that I see, there's documents for financial power of attorneys that it's not just the trust itself, but there's also ancillary documents. There's documents for healthcare. So there's already things in place to allow somebody to step in and avoid having to go to a state court proceeding or have to go through that. It makes it very much easier. And then I'm going to say reduce risk is number 5. And when I say risk, I'm not thinking typical lawsuits. What I'm thinking of is avoiding risk of having your family just contest and eat itself in the wake of your passing. So a typical situation kind of goes like this. Let's say there's 3 kids. Dad predeceases mom on average. Mom or whoever is the surviving parent. One child sometimes goes and takes care of that parent. Quite often, they'll either bring the parent and have them live with them, or they'll go move, or they'll live really near, close to parent. and they're the one caretaking for that parent. And that parent oftentimes says, I understand the sacrifices this child does, so they give them a little something extra. Maybe they give them 40% of the estate, and the other two kids each get 30. That's a recipe for a contest action. What happens is the kids that survive, or the kids that did not help mom or dad, that were not there at the end, let's say there's 5 years of in-home care before mom passed, the kids that weren't there, that weren't helping, not only is there a kind of a humiliation, not only is there feeling perhaps a little bit of jealousy, maybe they feel bad about themselves, and it causes them to react in weird ways. They'll oftentimes say undue influence or bring a claim against the child that did step into this. And by the way, this has happened in my wife's family, and it just destroys the relationships as a result. Somebody staying and helping grandma before grandma passes, grandma tries to do the nice thing, and everybody attacks that sibling. I've actually had a client where the siblings literally took care of mom the last 10 years, and they booted him out of the house. As soon as mom's passed, one of the first things they tried to do was get him out of the house because he was living in mom's house. You can't live in mom's house anymore. We're going to sell it. And he had moved his family in, and he had taken care of mom on a daily basis, like intense caregiving. And the kids reacted in a negative way as a result. So I'm going to put in there, reduce.
Exactly. People are full of, and this reminds me too much of a lot of close situations.
Risk of family conflict or of legal contesting as a result, because you can put in there, you can test this thing, you're disinherited. You can put in your living trust very clearly who gets to manage it. Since it's not a public record, they don't get to see all the numbers. So if you have, if there's kids, especially if they're disinherited, you don't want to invite that contest and bring them into court. You want to keep it outside of court, and you want to have there be a ramification if they start to rebel rouse. So you want to make sure that you have that. Number 6, and I mentioned it over here, that there was no estate tax benefit, and that there could be, depending on what happens. When there's no portability, then there's the estate tax benefit. There can be a benefit when you have a living trust. If you don't have a living trust, you're toast. If you do, then it's possible to use up the spousal exclusion of what they're entitled to and put it into trust for the benefit of the survivor. As of right now, they changed the law to allow the portability between the spouses, but that wasn't always the case, and it could go back. So it avoids that happening. There's also different types of fees and certain types of taxes that could also be applied on the event that there is a probate. Some states have different types of costs and fees, and this will avoid, by using that living trust, you can avoid those expenses by using the living trust and opt out. So there are those benefits. Number 7, there is some asset protection. And I'm going to explain in a few different ways. Number 1, there's credit shelter provisions, so that if you have a beneficiary and they have a creditor, that creditor cannot force the distribution out of a trust. If they're in a will and they're entitled to they're entitled to the estate, you could step in and take it. A creditor could step in and take it. Not so with a living trust. So there's that type of asset protection. There's also protections for special needs. If you have beneficiaries that are receiving state assistance, then there's provisions in our trust documents and well-drafted living trusts, not just ours, but they'll put in provisions that say to the trustee, do not distribute any assets if it will cause the loss of a state benefit, or if they have special needs and it would cause them to lose some sort of state benefit or access to additional capital. So there is an asset protection component. Let's say that you have a beneficiary, they're going through a divorce. That's another one where this asset protection, hey, no distributions, the trustee's in control. They're directed to not distribute if it's going to go to a third party or if there's a judgment creditor or something out like that. Next, 7, I'm just going to call it blended families. And I'll say blended families in special circumstances, but if you just have a will and you have money go to the parent, this happened in my family, by the way, money just goes to grandpa or grandma or to whoever the beneficiary is, and then they get married. So, so here's the scenario. Mom and dad are married. Dad predeceases mom. Mom gets 100% of the estate. She gets remarried. She predeceases her new husband. The entire estate just moved to the new husband, and you disinherited your kids. That actually happens. Think about, what's the famous case? Anna Nicole.
Mm-hmm. That showed. Yeah. Give me 1 second. Oh, that was funny. Oh my goodness. That definitely does happen. I'm trying to make... Okay. I'm trying to make sure there's nothing on my nose. Yeah, Yeah. Yeah.
Smith. Remember the 28-year-old playmate who married I think he was 88 years old, the guy that was in the wheelchair, and the entire estate was going to her, right? The kids contested, they jumped up and down fraud and everything else, but he had a wife who passed away. Here he is, he's got everything. When you have a blended family, you might want to make sure that your kids aren't disinherited because everything's going to the surviving spouse. So there are provisions in the trust that enable you to continue to stop that from happening so that it doesn't occur.
And depending on what kind of child you've been, it might be intentional. So don't expect for you to just be getting people's stuff just because you are blood related, okay? You need to understand your role. And, yeah. I'm not even going to say that because it was interesting for me to hear. I'm like, okay.
Where you've disinherited somebody. All right, multi-state planning. I'm going to put that up here.
Looking for luxury living in a prime location? Well, look no further than Beacon Place at Morningside.
Oh my goodness, man. This is
So most of my clients are real estate investors, and they have properties in multiple states. If you have property in your name, in a state, and you pass away, you're having to probate it in that state. So you end up with multiple states where there's multiple probating. One of the ways around it is just to use a living trust. Now, we use land trusts and LLCs, but if all you did was put your properties into living trust, and your living trust...
Hold on, because he said something that I definitely want to make sure we all hear correctly. And we got a little time. I can slow it down a little bit now. Hold on.
Does not have to be registered anywhere. You're having to probate it in that state. So most of my clients are real estate investors, and they have properties in multiple states. If you have property in your name, in a state, and you pass away, you're having to probate it in that state. So you end up with multiple states where there's multiple probating. One of the ways around it is just to use a living trust. Now, we use land trusts and LLCs, but if all you did was put your property...
Okay, that's what I wanted to hear. I thought he said land trust. Land trust, something I need to also keep in mind as well, because...
into living trust, and your living trust does not have to be registered anywhere. There's no state filing fees or anything like that. There's no upkeep. There's no tax return until you passed away, and even then it may not. What will happen is by putting those properties into the trust, now you don't have to probate in each one of those jurisdictions. So let's say you have property in 3 jurisdictions. Hey, I got property in Nevada and Washington and Georgia, right? I don't want to have to probate in all 3 of those jurisdictions. Let's say you live in Nevada. Okay, if I have a living trust, I don't have to probate anywhere. If I don't, and I just do a will, I'm probating in Nevada, Washington, and Georgia. So we want to avoid that. This is another advantage, is by using the multi-state property. And then there's also an element, I'm just going to put this back up here rather than writing down. Run out of space. For married couples, there can be asset protection as well if you're using separate property. The trust can classify property in a specific way so that you do get benefits. Somebody passes away too, and there's future creditors that come on with that spouse, rather than having your assets. So if let's say spouse 1 passes away, spouse 2 survives, spouse 2 makes some bad decisions and gets into some legal trouble or has creditors, if you're doing it right with a living trust, and you're following good advice from counsel like we would do, chances are that the deceased spouse's estate trust is now sitting there separate for the benefit of the survivor, but there's credit shelter provisions in it so that nobody could go get it. So if you have kids and you want to make sure that they're going to get an inheritance, this is one of those ways, because the decedent, the spouse who passed away first, their estate can go into a trust for the benefit of the survivor, but not available to the creditors of the survivor. So there are additional benefits by using that living trust. So there we go. So I laid it out. I did the cons and I did the pros, so you can make an educated decision. But I wanted to be very clear and cover fairly the 7 disadvantages of putting your home into a living trust. And then we can contrast it with those advantages. Hopefully you got value out of this. Share it with anybody you want to, and like and subscribe, and I'll see you.
I did definitely get some value from this. This was good. He answered some questions that I had from previous videos. The previous videos were a little shorter, so yeah. He did great. He did wonderful. You can tell he's been doing this for a while, for sure. So yeah, I like this. I like this. Okay, good information. Now it's time for you to make sure you do your research. Sit down and talk to the people you need to sit down and talk with. And also make some hard decisions, because everybody ain't worth your living time now. So why should they be worth your beautiful assets after you're gone? You know what I'm saying? I'm not saying be cold-hearted. I'm just saying be real. You feel what I'm saying? And do what you want to do. Because if you recall in the past videos, you also always have the option to leave it to none of them. None of them. You know what I mean? That's an option too. You want to leave it to a business, you can. Really fast. Ironically, that's what I remember seeing that happened to the Mar-a-Lago estate. That she ended up, it was too expensive. She gave it to the state, if I'm not mistaken. And then the state then gave it up because it was too much to manage. And so yeah. Yeah. Ooh, all right, man. Get your mind right. The next thing we need to be looking at is these fees, okay? To see how much it costs for this trust and, living trust. So, yeah, let's hop on that, because I know you don't want your business in the streets, and you definitely don't want nobody coming for your people. Like, cause that's crazy. The will situation, cause I always thought that was it. You know what I mean? Just do your will and blah, blah, blah. Get it notarized or something, official. But girl, this is why you need to do your homework, man. Whew. All right. Y'all have a good one. This is the last episode for this little series. I may do more. If y'all like these, get in the comments and let me know. Hit that like button. Share. And for sure, comment, man. Just comment. Of course, if you enjoyed all of these videos or any of my videos, hit that subscribe button. Come on back. Click the notification bell. Okay? Click that notification bell. Subscribe. If you like other type of content as well, I do talk about gardening. I do post videos in regards to gardening. That's going to be coming up more now. Also woodworking. This very loud truck. Also woodworking and just life in general, man. That's what I'm about. I prefer to talk about things that are important to me, right? And that can be important to a lot of us. So let's help each other, and we can get further. Okay? I'm with it. If you want me to support you, that's all I need you to do is support me, and I'll support you. You feel me? I'm about equal give and take. Sometimes it's gonna be a little, I get it, but let's balance it out. Right? Because this balance too, right? People don't think that's balance, but see, you can balance like this too. People think balance is just this right here, but I feel like balance can be whatever. It's levitation, baby. That's what it's about. To me, that's what balance is really about. That levitation. Yeah. All right. Anyway, I'm gone. I'm about to go and figure out the rest of my day. Y'all have a good one. Stay on top of handling that business, and we got this. We got this. Indeed.